WIPO China Intellectual Property Summer School. Nice to see you again. Topic for today's course is Machine Learning, AI, and Big Data Prediction for Patentability Sustainability, case study of SEP Royalties. Firstly, let me briefly introduce our Professor, Mei-Hsin Wang. Professor Wang teaches at National Yunlin University of Science and Technology. She is also the Fellow of Royal Society of Chemistry and CEO of China Biomedical and Technology Application Association. Professor Wang has achieved rich academic achievements, holding multiple positions in both academic and practical fields. More detailed personal introduction of Prof. Wang, you can refer to the materials we distributed before. Well, now let's invite Professor Mei-Hsin Wang to begin her lecture.
Good morning, ladies and gentlemen. Thank you for a very kind introduction. And thank you for WIPO and Nanjing University of Science and Technology for this opportunity to share my research and my experience on machine learning, AI, big data prediction for patentability sustainability using case study of SEP royalties. As my prior CV has been introduced, so we skip this page. Though today, my main focus is to apply machine learning, AI, big data prediction technology to identify, calculate royalty for standard essential patent. However, we need to briefly clarify the difference among AI, big data, and machine learning. Thereafter, we briefly introduce the manners how to monetize intellectual property, how in order to monetize intellectual property, we should sustain patentability as it is the must unless the patentability is certain or any further monetization of IP would be risky. Therefore, I will demonstrate my research how machine learning model can be applied to forecast the patentability stability. Nevertheless, the modern tool to identify substandard essential patent, the landscape of substandard essential patent, and company sub-profile will be elaborated through Patent Crawl, which is the tool developed by Inquatic, and how to judge whether the sub-royalty are reasonable if you are asked to pay for a substandard essential patent royalty, like 5G, LTE, BBC, and Wi-Fi are provided by the IP Lyrics, which is a company recently acquired by LexisNexis. So allow me to play through the tool demonstration. Thereafter, you will understand why we need to go a little bit of the theory and tradition class teaching. Do not panic for the term in English you may not be aware of. And after my explanation, you should be able to catch up. And for the terms in English you may not be aware of. And so now let's start the demonstration.
Recording in progress. Hi everyone, welcome to SEP Analytics by Patent Cloud. In this video, we will show you how to view the standard essential patent landscape using our Etsy SEP overview page. SEP Analytics features 5G and LTE quick filters along with 3 other exclusive filters that assist in evaluating the essentiality of standard essential patents. The newly declared filter can find the patents that are first declared as corresponding to a certain radio technology generation, such as 5G, 4G, or 3G. The widely deployed and well-maintained filters can sift out patent families that are deployed in over 10 countries, and those with no abandoned, lapsed, withdrawn, or revoked members. You can further narrow down your search with our advanced filters. Here you can select your desired filters, such as release version, tech body, or country jurisdictions. Click Submit to save your settings. Check your selected criteria here at the top of the page. You can see the overall numbers, such as the number of simple families under this criteria. After you have set your filters, you can view the various charts using the tabs on the right or by simply scrolling down. The declaration pulse chart shows you the declaration trend. Top declaring companies and their market share are shown on the declaring companies chart. With the global coverage chart, you can see the number of standard essential patents deployed in each country and their legal status. And here with the tech bodies chart, are the number of SEP families under each 3GPP working group. Take a closer look at the distribution of the working groups among the SEP holding companies. By clicking on any number in SEP Omnilytics charts, you can open the list of patents in this group. For example, you can take a look at Huawei's CT1 group. Here you can get an overview of the basic information for each patent, such as the patent number, application date, legal status, and corresponding technical specifications. You can select patents to save to Patent Vault or export. To save your selected patents in Patent Vault for further analysis or to work with a team member, click on the Patent Vault icon and choose a target folder. To export data, click on one or more patents to select, then click the export icon. You can export to Excel or PDF. Remember to select the data field you want before confirming. Thanks for watching.
Look at SEP Omnilytics exclusive features.
Hi everyone, welcome to SEP Omnilytics by Patent Cloud. In this video, we will look at SEP Omnilytics exclusive features, the Essentiality Rankings Indicator and Automated Claim Chart. We can see the percentage of patent families with high essentiality in the Company Overview table. After setting your filters and selecting a company, you can see the percentage of standard essential patents for each ranking with the Essentiality Analysis Chart.
We can see the percentage of patent families with high essentiality in the Company Overview table. After setting your filters
Before we go on, let's take a look at how essentiality ranking works. SEP Omnilytics essentiality rankings come from the combination of two indicators,
Let's take a look at how essentiality ranking works.
TS relevancy and claim scope support. The TS relevancy indicator shows how relevant a standard essential
The TS relevancy indicator
patent is to its corresponding technical specification. This is done by mapping keywords found in the technical specifications to each independent claim. The other indicator is claim scope support, which measures how relevant a patent's claims are to its specification. This is also done by mapping keywords. By combining the rankings for the two indicators, we get the essentiality ranking indicator. Now, back to SEP Omnilytics. You can take a more detailed look at how TS relevancy and claim chart support contribute to the rankings here. You can get the list of corresponding patents by clicking on the group. Select the patents you want to download or save in Patent Vault for later use. To see the automated claim chart for each standard essential patent, you can click on the indicator rankings. Here you can see how each independent claim for this patent is ranked, the patent's corresponding declarations, and technical specifications. Click on a ranking to see the automated claim chart. You can choose each claim element and the technical specification you want to map it to. Critical keywords are highlighted in the technical specification in yellow, and general keywords are mapped in green. You can see related terms and the 3GPP specification that defines the term by mousing over each critical keyword. Also, you can examine the automated claim chart for the claim scope support indicator by clicking on the rankings under claim scope support. Thanks for watching.
Hi Hi everyone, welcome to SEP Omnilytics
Hi
by
everyone,
Patent Cloud.
welcome to SEP
In this
Omnilytics by
video, we will
Patent
show you
Cloud.
how to look at
In
the
this
standard
video,
essential
we will show you how to look at the standard essential patent portfolio of a company using the company profile page. After entering the company profile page, you can switch between the current owner view and declaring company view on the upper left. SEP Omnilytics features 5G and LTE quick filters along with 3 other exclusive filters that assist in evaluating the essentiality of standard essential patents. The newly declared filter can find the patents that are first declared as corresponding to a certain radio technology generation, such as 5G, 4G, or 3G. The widely deployed and well-maintained filters can sift out patent families that are deployed in over 10 countries, and those with no abandoned, lapsed, withdrawn, or revoked members. You can further narrow down your search with our advanced filters. Here you can select your desired filters, such as release version, tech body, or country jurisdictions. Click Submit to save your settings. Check your selected criteria here at the top of the page. After you have set the filters you want, you can see all of the current owners are declaring companies of standard essential patents, and each of their market shares. By clicking on the name of a company, you can see the basic information and patent list for that company. For example, if you click on Qualcomm, you will first see the basic information about this company, such as the affiliates, and those that have 3GPP membership. You can also switch to the other 2 tabs, as a current owner and as a declaring company. By looking at Qualcomm as a current owner, you can see the number of simple families and active patents that Qualcomm owns. You can view the various charts using the tabs on the right or by simply scrolling down. The global coverage chart shows you the number of standard essential patents deployed in each country, and their legal status. You can see the remaining life of the patents in each jurisdiction in the remaining life chart. By clicking on any number in SEP Omnilytics charts, you can open the list of patents in this group. For example, you can take a look at Qualcomm's standard essential patents deployed in Korea. Here you can get an overview of the basic information for each patent, such as the patent number, remaining life, declaring company, and corresponding technical specifications. You can select patents to save to Patent Vault or export. To save your selected patents in Patent Vault for further analysis or to work with a team member, click on the Patent Vault icon and choose a target folder. To export data, click on one or more patents to select, then click the export icon. You can export to Excel or PDF. Remember to select the data field you want before confirming. Thanks for watching.
Most of us are often confused by abundance of modern technology terms. From time to time, there are always new terms and new technology, new apps, a new tool emerge in the world to cause the panic among us. Sometimes cause the worry and anxiety, which can be painful to us. But in my class, just relax, and it's simple. Let me review this page. It's clearly artificial intelligence. It covers all, as you can see. And AI, artificial intelligence, start the excitement from the beginning, and then machine learning begin to flourish with more focus. More recently, the deep learning continue to break through and drive AI artificial intelligence boom. Another terms of data science, which covers the overall zone. It can collect and prepare and analyze data, leverage artificial intelligence and machine learning to present the statistic manner for supporting business decision. And artificial intelligence is a technology for machine to understand, interpret, learn, and make intelligence decisions. Artificial intelligence covers machine learning among many other fields. Machine learning is defined as the algorithm to help machine improve through supervised or unsupervised and reinforced learning. Machine learning is the subset of AI and data science tool. So you may also hear deep learning in this slide. And you can clearly see the difference between machine learning and deep learning. For the process of machine learning, we input data and extract data, training a model, and which we choose to perform classification. For example, we input many photos, cats and dogs from the model system to learn classification. And thereafter, we will put new data to train models to test the new data. And if the learned data, the model can respond correct answer and the output is good, then our choose model is suitable. So if otherwise, we will try different model and study design to try again, while the deep learning it is combined the feature extraction and classification. Unlike a black box, we input the data to train the model chosen by us and get outcome. If the outcome didn't look satisfactory, we will choose another model to try again until it fits. We want to know how the model works exactly. However, as the Chinese slogan said, no matter it's black cat or white cat, as long as it catch mouse, it's a good cat. So when you choose the model, if it doesn't work well, you choose another model until you find the suitable one. In this slide, the example for machine learning, we create predictive model by discovering data correlation. So the first, we would need to collect some flower sample, and then we find out a set of feature properties, which means the property and the label species. And we train our chosen model to use the algorithm to find association between features and label. And the result will be a model that encapsulates associativity. Thereafter, this model can predict the label of a new sample based on its feature. So now you probably have a better idea. So regarding the models, I'm fully aware you might be terrified by those cross-professional knowledge. However, there are already mature commercial tools available. We only need to learn some basic concepts, as I just mentioned, and follow software guidebook for practice. Never be intimidated. Therefore, we only need to know, we need to have the data, and we clean the data, and we choose appropriate algorithm. Then additional basic knowledge about the machine learning. It contains supervised machine learning and non-supervised machine learning. This supervised machine learning trained data include knowledge label. Now, while the non-supervised machine learning data that they are without model labels. So the supervised machine learning can perform regression and classification. For example, regression means they focus the number of bike and raining basics on the data, season, and weather. For example, classification can be focused for the risk of diabetic patient based on the clinical data. The non-supervised machine learning can perform cluster. And for example, the classical car are similar displacement, fuel efficiency. And after we briefly introduce the model, now we will study touch upon model training and model evaluation. So first, we have to divide the data into training set and validation set, or called testing set. Then we apply the algorithm to incorporate training data into model. And the training model will encapsulate the association in the data and apply the model to generate predictions for valuation. And use the evaluate matrix to compare prediction to actual label, which is supervised or measures cluster separation, which means unsupervised. And then we repeat the work. So here, as you can see, so we start the classification, and we may classify them, and we may have the regression, have the dimensional reduction, and this is the classification and algorithm for the charts. But however, before you feel too much scientific knowledge, what I would like to simplify is this is the summary of our theory part. If your sample size is smaller than 1,000, and then it's recommended to apply the supervised machine learning model, which means classification. If it's less than 10,000, regression will be done. However, if your sample is smaller than 10,000, it would be better to choose a non-supervised machine learning model, which, for example, cluster or dimensional reduction, which we will not mention today. So that's for less samples, and above is with more samples. In the slide 11, in this slide, it's a mature tool we call PolyAnalyst 6.5. Here, we human do the loading, cleaning, manipulate data, text analysis, machine learning, and choose the report to export any report we want. The rest of the world looks so complicated. The base stage, they will take care of it. You don't have to worry. So apart from the prior setting, we legal profession actually only need to understand and explain the outcome in various forms in this report. So it's still a human intelligence us to make decisions. So for us to replace by AI, still have a long way to go. So in slide 12, this is plenty of mature commercial tool in litigation patent field, such as the Lex Mechanis. It belongs to LexisNexis. As you can see in the past, we need to conduct that research and personal relationship to get information necessary to prepare a legal case. But with AI, legal analytics, we have more precise calculation and more comprehensive for time saving. But however, we still want to make decision. As here you can see, 89% of summary judges will not be an option, but there's still 11% for you to make your effort convincing the judge, or maybe based on the situation, an outcome could be otherwise. Then we will continue our second part, intellectual property monetization. And this is my main teaching and my main interest. So patent, they can be licensing for royalty, and patent can be for sale and can be sold for trading. Patent enforcement can be performed through litigation. Patent-based partnership, patent-based merger acquisition, and lending, they are all common. Patent-backed securitization, tokenization are getting popular. So through AI, big data analysis, blockchain, non-fungible token, etc., emerging technology greatly changes the IP monetization process and the IP ecosystem. So how expensive the patent can be? I will take orthopedics case to explain to you how expensive a patent can be. I will take this orthopedic patent to explain to you. At least these 3 patents are worth more than 1.35 billion USD. And the story was happened in 2001. Los Angeles surgeon Dr. Gary Mei-Hsin, he accused Medtronic of trying to use a non-competitive agreement to sell his spinal fusion implement technology. So after 4 years struggling litigation, and ended in April 2005, after Medtronic agreed to a colossal 1.35 billion settlement, and they marked the largest payoff in the patent litigation history. And the second, in February 2006, Medtronic immediately sued Biomet and its orthopedic device, unit EBI spine LP of infringement, with 7 patents, including the 3 patents from Dr. Mei-Hsin in Medtronic single lock anterior cervical plating system using cervical spinal fusion. And these 3 Dr. Mei-Hsin's patents are US 6916330 B2 anterior cervical plex system, and US 6592586 B1 single lock anterior cervical plex system, US 6428542 B1. It's also naming the single lock anterior cervical plex. And the B1 indicated that the patent is B1 indicate that patent is granted before 18 months, and B2 means it's after 18 months after publication. So in case some of you are not familiar with patent, I would like to open one of the patents for you as example. For example, this is one of Dr. Mei-Hsin's patent. If you look at the 12, that's international harmonized, that means it's the country. And the 54, that means is the name, the title. 76 means the inventor, and 10 is the patent number. 45 is the patent date issued. You see the abstract here, that will be number 57. They have the field of search 58, US classification 52, international classification 51. And there's some related US application, the reference 62 and 60. So they were filed in, you look at the 22, 2000, July 17. On this is the representative drawing. What is the most important? The right of the patent will be the claim. So in this patent, they have many photos. Here you see the related application for the first column. And then they will give you the background of invention, the field of patent, the description of the related art for you to understand the patent. And it's quite a long description and very common for pharmaceutical patents. The object of this invention, that will be the main object for this invention, and they will claim here. And then you scroll down, you will see the summary of invention. There will be the overall summary of invention, how this patent will work. And they have the brief description of each drawing, as we have seen many drawings in this patent. And then the detailed description of the drawing. For each drawing, they will give some detailed description, how you can use this pattern. And they also call embodiment, the examples. So it's a long pattern. And the legal part will be the claim. I want to show you the claim part of this pattern. Here, when you start to see the numbers, here he says, what is claimed here is a plate system adapted for use in the anterior human cervical spine for contacting the anterior aspect of at least 2 cervical bodies, a plate system comprising a plate having a longitudinal axis and a length sufficient to span and space and overlap portion of at least 2 adjacent cervical vertical body, and the lower surface for placement against the cervical vertical body, and an upper surface opposite, say lower surface being concave along substantially portion of the longitudinal axis of the same plate. So for one, they call independent claim. And if you look at the other part, the plate system of the claim 1, that means they depend on claim 1. Depend on which claim, depend on claim someone, then they were dependent claim. And this is the plate system of claim 7. These are all dependent claim. So the only one is the independent claim, and then we would like to see whether there are other independent claims. Yes, 32, I believe. 32 is another set of pattern. There's the independent claim. So independent claim, they don't depend on anyone else. So you see 32 depend on 33 depend on 32. So this is, I want to tell you. So independent claim is more important. Dependent claim is depend on the set to the previous claim. On the, I also want to show you. So here, obviously, 64 is also an independent claim. And how many claims they have for this one? Claim 100 is also an independent claim. Claim 87 is also an independent claim. And they have over 123 claims. These are their legal rights. The claim, this has a certificate of correction. If you make some mistake, you make some corrections. So this is the general form of a patent. I want to show you before we continue more. From anticipation to litigation or monetization or market value calculation in unfair competition case, and the make decision will be more confident through supporting from AI, big data, and machine learning, not only for invention patents, trademark, design, utility model, domain name, copyright, etc. Should also monitor the value of these assets. An AI big data machine learning tool can support a foreign activity. For example, litigation to find the killer arguments, and compared to the claim construction, search for wrapper and definition of the claim for foreign shopping or for appropriate call of legal actions. In opposition process, we can search for the patent families, and search for file wrapper for pending actions. In patent examination process, AI big data machine learning tool can sharpen your argument and future examiner objections. For monitoring the corporate management, AI big data machine learning can monitor competitor action, technology trend, and MP, which is the abbreviation of a non-practice entity, or PAE, patent asserted entity actions. For infringement actions, the AI, those modern technologies can support foreign shopping, find the killer argument, learn where two opponents are, inform user and designer about the degree of freedom, and learning the right legal basis, and performing novelties and individual character check and overall similarity check. And for anticipation, AI, big data, and machine learning tool can perform monitoring and estimating the anticipation pattern for refusal risk, examine the anticipating legal pitfall, freedom to operate. On the slide 7, in slide 17, the patent value is similar, very much similar to the real estate evaluation. In certain area, patent can be priced, be loaned, and be sold, and patent is required as registered and own its own legal position. However, patent is unlike real estate. The real estate is tangible assets, and it's a limited resources. It will not be expired. Patent is an unlimited resource if service or product to be duplicated. And however, patent will be expired after 20 years of application or the lapse of the maintenance fee. Design pattern, utility model, different life period in different jurisdictions. In this slide, you can view some example of pharmaceutical deal based on high-value patents. And in this slide, you can view some examples of litigation damage award based on very high-value patents. In this slide, you can see the common rules for the royalty in different industries. For computer general manufacturer, for consumer industry and chemicals, they are around 2 to 5, but while the pharmaceutical industry, that's around 5 to 10. And here is the new tool now used very often, the patent securitization. That's familiar for you. However, the deal amount was also significant and the process is sophisticated. Normally, this is a simplified securitized model. The special purpose company take care of the patent assets from the patent owner or licensor, and the investor invests on these securitized patent assets, and which has the royalty payment as the guarantee. And of course, there are credit enhanced and bankruptcy removal mechanisms to protect the investor. Even patent under litigation, it can be securitized if the huge profit are involved. For example, this case involved 40 attorneys for 6 years. The anticipating FTC is a full relative version of the Lambi-Mudin 3TC, discovered by and patented by Emory University. And in 1996, licensed to Triangle Pharmaceutical, and later on acquired by July Sales to complete the development and market of the product approved by FDA in 2003, July 2. FTC and 3TC are improved synthesis of this BCH 189. It's a racemic nucleoside based on the Journal Organic Chemistry 1992, which was licensed into Baruch. And Wellcome later was acquired by the Grasso. So the Emory University finally received $525 million from all FTC royalties, which July shared 65%. Royalty funds responsible for 35%, and July further paid $15 million for amending the contract. So as you can see, how well, it's really cost a fortune to hire attorney to amend the contract. And July stocks price up 3%, and that's $625 million. Created on the announcement day. So in this case, if you deduct the 65% of $525 million US, which July paid to Emory University, there are extra $268.75 million US again by July on the announcement day. And actually, the stock price will continue to up for several days. So it's a really good business. So in this slide 4 is to explain the relationships among these participating parties. And the 25, this is what I would like to say. Driven by AI, big data, and machine learning tool, whoever is interested in intellectual property rights can play a role in the new ecosystem, because the AI help you to evaluate the value, patent sustainability, and also the risk. So for people who are not familiar with the patent, they can participate. An insurance company will involve, and certainly everybody will be enjoy the benefits for the new emerging technology, created a new IP system for us. This is the first part of my work. We take a few minute break and then we continue. Okay, now is the third part, how I use machine learning to predict the patentability. Because when the patent is very valuable, and then people will try to restore your patent, revoke your patent, because they also want to take a part of the profit. So this is this case. I apply machine learning to study patentability through patents which have been filed individual invalidation, re-examination proceedings. If you remember what I presented in the first section, we have to train the model first before we perform the prediction test. And the accuracy validation will be performed by comparing the machine learning model training outcome, and versus the existed invalidated re-examination decisions and the case we chosen. And if the outcome are satisfactory, then I will perform a prediction test, and the outcome will be compared to the existed invalidation re-examination decision for accuracy check. And this is a particular region for 21 years. I prepare data into two groups. Group 1 is the valid group. Group 2 is with the invalid claim, which was revoked by the state office because they failed their re-examination invalidation process. So we have two groups. And then we have to, that slide 29, they demonstrate how I train the both outcome, and you can see they are making progress. And overall group 1 and group 2, and the red below is the invalid group, getting better. So this is how we train the system. On this slide, they present the testing outcome for both group 1 and group 2. So you will see the outcome is getting close. So this means this model we chosen is appropriate. This is just to prove what I told you in my first section. And then in this research design, again, is the particular region of the data for 21 years. But I divided them into 3 groups because when your patent was following the examination, invalidation process. They are not only 2 outcomes. One is your patent will totally destroy. One is your patent is partially or fully survived. But if we divided this survived patent to partially survive, and fully survived, there will be 3 groups. So I want to see what this, if I divide it into 3 groups, the data will be what will happen. And so we see the testing. We have to train the system first, and again we can see the invalid group looks better, so the more accurate in the invalid group. On the slides present the testing outcome for group 0, 1, 2, 3. This is the testing outcome. So again, it shows the invalid group present pretty well. The third design is in this specific country, and they have different small provinces. So I divided the case into the provinces, and also 3 groups: patent fully valid, patent fully invalid, and patent partially valid. And I would like to see the training outcome. Again, it proves the invalid group shows the best outcome. This is a training outcome, and the testing outcome is consistent. So the proof I choose the right and appropriate outcome. So this is how we process the use machine learning to predict the patent sustainability. After we have the way to choose the patent with better patentability sustainability, then we can continue the due diligence part for the future patent monetization. I have a tool called Inquatic, which I use to train my students. And it's very good for doing due diligence. They can do the coverage of the status. The dashboard helps to decide what keep going on the analytics to start right away, global coverage, remaining life, and pendency in a portfolio worth your attention, which you have seen in the 3 videos I just presented you at the beginning. And the technology covered by the portfolio extract from the patent, IP's international classification. So what is due diligence? Due diligence is you have to cover the owner's invention application information, historical highlights, and the quality of the value, on the licensing and deal when you do a licensing or deal negotiation. The assets of preparation phase, IP due diligence, and the single legal follow-up are also very important. On the 40 slides, I show you the general deal process. So when you are interested in a particular deal, you have the primary due diligence for the assets. And then once you have the first stage communication, have further interest to dig further, then you have the IP due diligence. And then after, you still have to have the term sheet contracts follow-ups as well. This is the general deal process. So during the assessment steps, on the goal for due diligence is to identify, investigate the assets and their opportunities. So this is the main purpose for that. For preparation step, due diligence is to build business case, validity opportunity. The goal for IP due diligence is to assure the ownership freedom to operate an IP space for assets meeting the needs and association business case, no matter in writing phase, oral phase, or document examination. And this is the fully IP performed due diligence for you. It's from NVIDIA, very famous case. So you will quickly see the quick view in just a few words. You will get the IP landscape of a company, NVIDIA. So you can see that how many patents they transfer the licensing, they litigate the pledge, and what patent is called application is called only patent. And regarding the main assignee, if it's belong to NVIDIA, how many of them? Co-applicant, co-ownership, the detail you can see. And also the active and the pending condition for NVIDIA's patent, where they have filed in US, in China, in Taiwan, UK, Japan, Europe, Korea, Australia. And you can view the trend of their patent based on the country. And you can easily see which international classification they have applied, and whether they have transferred their patent, licensing their patent, or pledged their patent. And also the quality and the value of this NVIDIA company, and they are the standard format. Just quickly you get everything. Due diligence can be easily performed by patent claw. And here you will see how many patent families compared to their competitor, Intel. And also their famous patent who are following their patents. Here you see which patent they have been followed, whether it's in a very passive area, where are the potential infringer. So after I present you the AI machine learning big data analysis tool, they can automatically perform IP landscape. We will continue our final part. The final part is we calculate the SEP royalties using the case of 5G and LTE, BBC, and Wi-Fi, 4 cases. I hope you will learn it. So SEP indicated the claim. They say invention must be used for complying with a technical standard. For the SEP issues, patent declared data is incomplete. And the report provides a ranking of the declared patent are rely on a very raw data. So it was difficult for you to consider. It's a rigorous data matching and cleaning, false positive determination and cleaning, and there may be worldwide ownership changes as well as the corporate cheese, merger acquisition, beneficiary share, accurate patent family expansion, unclear. So standard setting organization website and from they should have standard contribution information, which is typically not hosted by the standard organization website, but available within several standard consortium that develop the standard. For example, 3G, 4G, 5G, ETSI, they were contributed by 3GPP, AVC, HEVC, VVC, ITUT contribution were available at the JVC, JCTVC, JVET portal. And Wi-Fi, Bluetooth contribution are available at IEEE Mental portal. And IETF contribution are available at the IETF FC portal. Contribution may be submitted by single company or comp group. And a single contribution company, a group of contributing company, or a first contributing company and other supporting company. And contribution is often different type, category, and status. And then whenever we mention about the type, that could be work items, the change they request, input, output, document, drop, etc. And we will mention about the category that have the additional feature, correction, editorial motive, functional motive, or status, agreement approved, in cooperating noted, rejected, etc. Before we start to calculate the example which we will provide for today to calculate the essential standard patent royalties, I have to explain how this patent alliance was formed. First, they have to have the industry standard technology, and then they have intellectual property research team organized to set up. At the same time, they have to set up a technology standard, appoint independent essential standard patent expert, and they also have to announce to the world to recruit all the essential standard patent related to this specific technology. On the other hand, they have the marketing group. They have to find a licensing agency selection or licensing representative appointment, licensing trustee set up for remove vehicle, special purpose vehicle for bankruptcy remove control. They have to conduct market survey and market intelligence study. Then thereafter, all these essential standard patent assignees, they will meet together to discuss the licensing package program and the contract. And after that, they have to send all these proposals to individual country for anti-competition authority approval. After the country's approval, then they can activate their patent alliance. This is how these essential standard patents start to collect their royalties. For patent law in the sub-analytic, the SEP must include technical report and specification information, and all the SEP are inspection for example, 3GPP technical report specification numbers, and whether the technical report specification have been withdrawn by 3GPP or not. They have some prior investigation has to be done. And the SEP must be a published paper patent application. And SEP only, it was part of the function for patent crawl, developed by Inquatech company. And SEP only consider published patent publication because only published publication can be scrutinized for essentiality. Provisional or withdrew patent will not be included, and the deduction is based on the hypothesis that a SEP owner will eventually declare a current provision withdrawn patent application in the future if they deem the patent to be a SEP. And the SEP family must include patent with the ETSI declaration number and only include the simple family numbers. And SEP only use the EPO DOCCB simple family definition. So it's a collection of the patent documents that are considered to cover a single invention. Okay, so we have seen those SEP omelette tutorial at the beginning, and then we have the SEP omelette tutorial for essential ranking, and also have the SEP omelette tutorial for company profile. So you are aware the tool they could have the overview, and I have used the NVIDIA as an example, and they can quickly, if you type in the button, they could essentiality ranking perform for you, and also company profile. So here, on how to conduct that, I will just have some tips, reminding for you. You upload and map your own claim to any 3GPP technical specification report with the SEP claim chart feature, and then you input the content, claim content. And I have shown you the important pattern. What is the claim? Claim have independent claim, have a dependent claim. Use the Dr. Mei-Hsin's pattern at the beginning part of our class today. And we click the plus create button on the upper left to open a pop-up window. And then we can enter the title of any claim into the text box and click continue. So you have to note you enter English claim only and at least 100 characters, but not exceed 10,000. After that, we have to define the mapping scope. So select the scope, for example, the desired 3GPP technology specification report to map the claim and the number of the result to be displayed. And we click more plus here for more setting and click confirm after confirm the setting. So we click the button. We click the button on setting icon on the right of the modifier of the current claim scope. So you can see the high, the relevance, the technical score relevance is high. You can review the specification number. View the claim chart summary. They could provide you summary. That's very important. That's how AI help. Click on the TR relevance ranking, high, partial, or low to view the claim chart. And summary for the TS relevant ranking generated by mapping the claim to each most relevant TS and TR. You see the outcome. Quickly, you see the category. You can see the reports. Click the pattern summary. You can click the pattern summary. They will give you the summary. You can see the whether they have the litigation on district court, ITC, or PTAB, or in CFC. So you can review the litigation history. So sub-licensing Sub-licensing, they can be valued and determine sub-portfolio offer for license. Prepare for friend negotiation, identifying the numerator and denominator to measure the patent holder market share. And then identify standard subject to SEP in the complex value chain of the supplier as the SEP holder approach OEM and at least model supplier. And monitor sub-filing, sub-changes of the ownership and litigation to quantify risk and plan royalty payment. We can identify industry related to M2M, IoT, or IoT, and standard development initiative to have a seat at the table where the future connection technologies develop. And also sub-licensing can be aligned research and development investment, standard development, patent prosecution, patent portfolio management, and licensing monetization strategy to file valid and essential patent and to commercialize the SEP in a world licensing campaign. So compare SEP portfolio for cross-licensing, negotiation, and monetary competition, and making sure to sustain revenues both on the downstream product and market as well as the upstream licensing market, and monitor competitor standard development, investment, contribution code, and identify new standard group to maintain leading position in standard development. But actually, the SEP Omnic is not the only tool. I would like I'd like to show you another very famous tool. It's called IP Lyric. For IP Lyric, it's similar. For you can select all. For example, in 5G case, you can select all or standard document or data provide. But we are aware they must belong to 3GPP contribution. We can identify all Wi-Fi 6 contributors. If it's Wi-Fi 6 contributors, then it will be IEEE contributor. Actually, it's a very good practice on counting and evaluating declared subdata. You can also identify or incorporate VVC contribution. We know the VVC contribution is belong to 3GPP. The standard contribution data can be applied on standard contribution data on competitive intelligence to identify potential SEP owner. For standard contribution data and R&D management, they could contribution help to coordinate standard development team. For standard contribution data and valuation step, that could cross-correlated contribution with SEP data. Standard contribution data and prior search use useful task contribution data to draft value and essential claim. So use those commercial tools that could support you to identify potential SEP owner. You don't want to pay the royalty to people who are not a SEP owner, right? So who is the standard development leader? Who are the first contributor? Who increase contribution to a certain standard? It will be very easy to use the tool. And which are the technical contributor and what rate of contribution agree, approve, or incorporate, and who else are in the contribution. And we can search for index standard contribution, identify relevant contribution to your invention, and identify meeting at first publication day. If we take this 5 years example, we know Huawei have many patents, Ericsson, HiSilicon, Nokia, Qualcomm, Samsung, ZTE, Intel, LG, CATT, NTT Docomo, MediaTek, NEC. So standard contribution and prior search, they have the algorithm. So they have R&D, internal discovery, disclosure, submission standard contribution, working group, vote to approve the standard, an IP management team, filing and prosecution, patent review, provisional or claim or approved SAP, draft patent claim. So you can decide you want to licensing, you want to litigate, or you want to sell. So that's how this modern tool helps. And now we will continue the practice how to calculate a royalty. So when you receive a letter from someone asks you to pay, for example, they say, I ask you to pay 2.275 per unit because your product using my 5G SEP patent. Then you will have to ask who else also contact you because one standard may have many developer, many have different alliance. So how can you calculate the aggregate royalty? And how do you know the royalty is fair? So you use the tool, as we told you, IP Lyrics or SEP Omnic. And first, we have to identify the person who contact you. What percentage of the royalty, how percentage of the patent, SEP patent he owns. And then we can know what is the reasonable percentage of the royalty, what is the reasonable money, and multiply his share percentage. That's the principle. So In first step, you need to identify self-owner's share, as I say, patent family, for the respective standard, share a respective market and time. Choose the standard version, and jurisdiction where you use, because if he has a patent in 30 countries, you only use product in one country. Certainly, you only use you only need to pay for the fees in the specific country. You don't have to pay for the royalty for 30 countries. And then the table on the right shows the patent owner share. It's very easy to use SEP Royalties or IP. And patent family active granted, how many of them? And at least one of these foreign office, whether it's in US and EP, result in how many patent families. And that's for if it's Qualcomm asks you to pay, it asks you to pay 2.275 per unit, then you can calculate his share is 12.9. So if he asks you to pay 2.275, that was equal to only 12.9%. So the overall royalty for the device will be 17.64. Then you have to think whether it's reasonable. For the overall, it's 64 for the whole device. If it's too high, that means Qualcomm asked too much. Okay, now if it's then we continue the next example. Another example, for example, if someone asks you to pay 0.75 for the royalty because he claimed your product XYZ has used this MBA IoT, LT, and SEP technology. Then the first, as we have done in the previous case, you have to find out who really owns this patent, right? And then you have to calculate the share, how many patent family these people has or this company has, and then the percentage of the people who ask you to pay, and then you calculated the overall royalties if based on this request and see whether it's reasonable or not. For example, it asks you to pay 0.75 for per unit, and his share is 17.6%. For example, if Huawei asks you to pay, then the overall royalty will be 4.26 compared with the wholesaling price. You decided whether it's reasonable or not. Then your further consideration is, apart from Huawei, will other people will ask you to pay for the royalties? That's the consideration you also have to have in mind. And the third example, if someone call you, write a warning letter, you have to pay me 0.2 per unit. And then we have to check using the software SEP Royalties from Inquatak, or we use IP Lyric from Clarinet, because now the company I always belong to, IP Lyric belong to LexisNexis, not Clarinet. And then we have to calculate the percentage, how much these people who claim your royalty, the share of him or he it in this field. And then we can check use the system to check whether it's true or not. And then, for example, if it's via licensing, then we can be aware its percentage is 3%. So if the 0.2 is equal to 3%, the overall device will charge you 6.67. Then will it be reasonable? And what other people will ask you to pay as well. So this is how we calculate it. Another example, Wi-Fi 6. If someone call you, you must pay me 0.5 US per unit because your product XYZ have used my Wi-Fi 6 patent. Then you have to find out the specific company, how many patent family he owns, what percentage he has, what patent office does he has this patent. And then, for example, if it's a Cisval, And then the percentage is 13.6. So 0.5 US dollar equal to 13.6 percentage. Then the overall you will have to pay 6.68. 3.68 US dollar. Is it reasonable? Is it fair? Where other people will also call you to pay. So you have to have this all in mind. So I have presented you all the necessary cases for you to practice how to calculate the royalty. Does the share calculation drive the aggregate royalty calculation? Yes, there are different approaches to calculate the share. You can refine the data by setting different cutoff day by using the tool, different jurisdiction, or consider only certain version of the release of the standard you have involved, and all the changes of the patent holder patent family share, and however, also a range of the aggregate royalty price provide a reference point. So how do you know what is reasonable or excessive? If you already choose the deal with other SEP owner, then you know. You can use IP lyric or SEP Omilyk to compare the aggregate royalty with earlier deal for a comparison, and there are publicity available data point for you to compare. So a licensing for, you can use the IP lyric, now it belongs to license now. Value and determine the SEP portfolio offer for the license, and identify the number and denomination to measure patent holder of the market share. You can calculate the aggregate royalty share to prepare for fair negotiation. Identify standard subject of SEP in a complex value chain of supply as SEP holder approach OEM or at least module supplier. And we can monitor SEP filing, SEP changes of ownership, and litigation to quantify risk and plan for royalty payment. So for summary, there are plenty of the commercial tools I just mentioned. And any data in all days, we based on the person's experience and information from the industry, and the court deal with the case swiftly, and the judge favor defendant. This company is inclined to settle, or the company with a rewarded considerable amount of damage. But with legal analytics, we can base on the data, choose strategy, have very precise, for example, 212 days per patent case. 70% of the judge will favor defendant. The company have 95% will settle. That will be more precise. And in all days, we look for the law, regulation, doctrine of precedent, regulation and court, legal issue, and legal reasoning. But now we have a judge's preference, we have a case outcome damages, we have attorney performance, we have client statement, we have the trial hearing time, we have successful motion strategy, we have patent litigation case, we have precise patent and action. But without AI, without big data analysis, without machine learning, it's always difficult for you to conduct business in legal field, not even to mention in intellectual property field. For example, if you look at this parallel case, when I make it in a smaller size, they all look the same. But when I maximize them, you immediately notify they are different products, but they certainly cause the confusion and dilution for the original blend. But without this AI big data technology, mature database, you wouldn't in a few seconds to find out where are the identical competitors, location in EU or US or Benelux or states, or the competitor just with certain elements similar, with some element the same or similar, or they register in a different class, or actually they are inactive. So just few clicks, you get all the figures. Even the call, they have to use this modern tool now, because if you look at this for March, They look so different, but if you look closely, the words is the same. The images all with apple, grapes, and leaves. Actually, the elements are the same. For clarinets, they have developed the naming tool, so they're very good for you to use this to search before you name your company, name your product. They have their calculating, identifying, searching algorithm for identical with other class, phonetic identical, one letter added, one letter change, phonic prefix, mild word, suffix, phonics suffix, or identical. So you can see they have this even the vowel exchange, consonant sequence, also non-dictionary anagrams. So we saw the AI big data analysis. How can you find a similar potential infringer? Or how can you design around? You certainly need their help. This is another tool by CompuMart. It's a CompuMart by Clarinex. It's the same. They give you the full list. You can quickly click in the citation, alert status, their class of registration, the good of services, and the owner. You can just pay by the month you have used. For trademark allocation globally, and even with the highlights, you can have set alarm sending the progress from time to time. Once you search that, simply choose the image to drag in, or type the class or the name of the trademark. Few seconds, they search global database for you. Without even the code, Vienna code, and they can even give you suggestion. That's done by AI. They give you the suggestions, the similar code you should have checked, similar images, and even the global litigation map. This is the tool I used to train, and it was developed by we Chinese. So they can conduct pattern search, design search, SEP only links, and they could have due diligence, quality insights. So nowadays, even essential standard data, they can be determined as essentiality and whether they are friend or not. And you can check quality and validity, and they could help you to conduct portfolio search analysis as well. You can even have user case whether the similar case have been done in litigation. Basically, they list all the information, conduct claim construction, para search, and give you suggestions. But however, decision making, you want to have patent, transact, licensing, or asserted, that's based on the human decision. So they could help you that in this database, Patent Cloud, they have covered China, EU, India, Japan, Taiwan, US, and WIPO for test. And they also use the US pay and PTAB official gazette maintain and how to whether they have the pay for the maintenance fee. And you can search file wrapper by size, pay by the size, the payer PTAB by file wrapper. So for patent prosecution, the notice of allowance, remark, rejection, post-grant proceeding, petition, response, reply, decision, all can be fully downloaded and for your analysis. So for this AI data mining for validity evaluation process, they can even give you the detail individual patent, whether they have been eligibility up to pre-AIA, based on what condition, based on which regulation. So even the image identification, design, search with word, with images, with specific elements, you can all adjust your search. For you to design a new product, without infringing other people, or to find people who may have infringed your inventions. So it's easy to access the visual information, and they have opened their quality and value criteria. So nowadays, the modern technology, AI, big data mining, machine learning, they have provide actionable pattern intelligence to pattern quality and limit the design possibilities. So this is just the image. Just few click, you can identify pattern quality values. They can have the word expansion, give suggestions by AI to help you to reduce the entry barrier, or also reminding you what could be you may possibly forgot, even you are in the expert in the field. They could enhance the search, and they have keyword expansion, and even for, this is an example for artificial intelligence, and they could have the affiliation correlations, find affiliations. So you can search file wrapper with validity issues. For post proceedings, claim construction alarms the subjects prior art in rejections. The VI can offer semantic prior search, secondary degree prior search, family prior art, whether they are high relevant or not. They can support claim construction, supplement argument, prior art reference as exhibit. So that they help you to make decisions with great context and save your time, reduce the cost, optimize the legal structure, prepare the case faster, minimize the refusal risk, identify class for available search and watch, and estimate the likelihood of success. So they help us for the freedom to operate, clearance opinions, right association with the patent owner. Patent infringement could be the biggest liability for seller, and information for designer wrong, collection necessary related patent, prepare for future merger acquisition, licensing or settlement, generate new IP for future business and risk management, provide evidence for the current environment, and avoid willful infringement in the future. Clearance search, compare process for device with claim, review file wrapper of selected pattern, review validity of target pattern, when to conduct freedom to search, the prototype stage, design freeze, first manufacture, use, sell, launch or follow-up product with new feature, or prompt after receiving case cease and desist after litigation start. So IP acquisition process could apply these AI big data to support IP strategy, for example, merger acquisition licensing, IP utilization process for the final threat and opportunity. We can support the business and product object, and support the investment on IP resource for competitive advantage. We can support the decision making, investor request for freedom to operate start. Basically, we will not be replaced by AI because we are the one making the decision. So clearly, prior search, patentability determination, patent acquisition, patent assertion, patent intellectual property investment, can all be done by AI. They done better than the entry-level human being. But the law is nothing more than a process to be coded, and the analytical engine, of course, is better than the emotional human being, but with proper rest, we are better than the machine. If software always there, yeah, they are there, yes. But lawyer no longer need to have office, but can crowd-based law firm adequately protect their client? And lawyer more subject to be hacked by intrusion, yes. And can the virtual lawyer ethically represent the client? Not sure. But what does the lawyer can offer now? We have to think. A lawyer responsible for protecting intellectual property that might eliminate change the profession, or can experience intuition to be called a machine. Lots of questions. So is my class today. You are welcome to have more questions. I'll try to answer you. Thank you very much.